Good afternoon, everyone. Welcome to the Georgia Justice Project 2024 Legislative Kickoff webinar. My name is Brenda Smeaton, and I am the legal director here at GJP. I'm going to be turning it over to my colleagues, Wade Askew, Ann Colleton, Dominique Harris, and Paige Jan, and our special guest, Charlotte Garnes from Reinforce in a few minutes, who will provide an overview of the issues and bills that GJP is working on this session. So I can see that folks are still joining us online, but I do want to go ahead and jump in. There's a lot on our agenda this year, and some of it's rather technical, so we want to leave some time for questions and clarifications at the end. So if you have a question, please use the Q&A box and type in your question, and we will try to get to as many of them as possible. So first, I want to take a moment to thank each of you for being here. Life seems to get busier and busier all the time, so your time is precious. And whether you are a partner, an ally, just joining us for the first time to learn more about our work, and especially if you are a person who has been impacted by the criminal legal system in Georgia, either yourself or somebody that you love, we are grateful for your presence and spending your time with us. So on the next slide, I am going to take just a couple of minutes to tell you about GJP in case you're not familiar with us. And even if you are familiar with us, you might not know about some of our new programs. So we are a legal nonprofit organization. We've been around for 38 years. All of our work is guided by two overarching goals. The first one is to reduce the number of Georgians who are under correctional control. So what are we talking about when we're talking about people under correctional control? We're talking about people who are in prison or jail or juvenile detention, and people who are not locked up, but are on probation or parole and subject to the costs, rules, and the stress of the constant threat of incarceration that come along with being on supervision. Our second goal is to reduce reentry barriers for those that are formally justice involved. And that can mean everything from reducing both formal barriers, legal barriers, and informal barriers such as discrimination, to employment, housing, occupational licensing, and overall just the barriers to stability and well-being that a person incurs after they've come into contact with the criminal legal system. So we do this at GJP through a three-pronged approach. We provide legal representation and social service support to hundreds of Georgians each year who cannot afford an attorney. We work to change the system through policy advocacy, education, and administrative changes. And then we also collaborate and build partnerships with a wide range of stakeholders and communities. The next slide shows how GJP has expanded over the years and how we are working at every stage, or most every stage of the criminal legal system now. So we continue the services that you may be more familiar with. We continue to represent individuals who have pending criminal cases in Fulton and DeKalb County, and to represent folks who need help clearing their criminal record all around the state. We also continue to work with the Metro Reentry Facility, which is the only prison in Metro Atlanta, helping the men who are there to remove legal barriers to successful reentry. But we've added a couple of new programs in the last couple of years, which you might not be as familiar with. We added a program to assist folks with early termination of probation, a warrant resolution clinic, and Restorative Justice Georgia are programs that we launched last year. And at the end of last year, we welcomed a new legal fellow who is focused on resolving driver's license suspensions that are related to a failure to appear. So lots of change going on here, lots of new services. What we try to do is add programs that fill in some of the gaps where people may not be able to obtain legal representation if they can't afford an attorney. On the next slide, this work that we do with individuals is what drives our policy agenda. So in representing and consulting with hundreds of individuals a year and learning about their legal issues, we hear their stories and we propose legislative solutions that we think are feasible to address these issues. And we also work in We either build or participate in broad coalitions such as the Second Chance for Georgia campaign or the Justice Reform Partnership. We also work to build bipartisan support for reform at the Capitol by providing information to legislators on what other states have done, bringing forward individual stories of the people we've represented, or the people that have reached out to us to share their story, and providing data on the benefits to both individuals and communities of reform and the positive impacts that reform can have on public safety, which is of course a topic that's getting a lot of attention at the Capitol. On the next slide, speaking of public safety, this highlights the magnitude of these issues in Georgia. So while we have the 26th highest crime rate in the nation, we have the fourth highest rate of people who are incarcerated. And by far, it's not even close, we have the very highest rate of folks that are on probation. So this puts Georgia in the unenviable position of having the highest rate of people that are under correctional control at any given time. So on the next slide, we always want to center the fact that racial disparities exist everywhere in the criminal legal system, and Georgia is no different. And some of those disparities are more pronounced in Georgia. So disparities based on race exist at every single stage of the criminal legal system, from policing to arrest, incarceration, which is what is shown here on this table from the Prison Policy Initiative, on up to how an arrest or conviction history is used, sometimes many, many years later, to deny opportunity, to deny employment, and perpetually punish many Black Georgians who have a record. The next slide shows that the result is shockingly 4.5 million people have a Georgia arrest or conviction record. And here we are just breaking those numbers down a bit to dispel some of the myths that might be out there about who is in that 4.5 million people. On the last slide, and I am going quickly because I want us to be able to get to the substance of what we're working on, I just want to highlight that this overcriminalization in Georgia has led to a crisis for both individuals seeking employment, but also for employers who cannot fill jobs that they have. By marginalizing qualified workers who are currently or formerly, have been touched by the system, whether it was, they're still on probation or whether they had an arrest or conviction that was 10, 20 years old. That is why we at Georgia Justice Project are focused on expanding record clearing and have worked with allies such as the Georgia Chamber of Commerce and the Metro Atlanta Chamber to improve liability protections for employers and figure out what other reforms might promote second chance hiring and help employers to feel more comfortable. Also, we just continue to engage in dialogue with employers about the benefits of second chance hiring, which are well documented, and how we can work together to strengthen our communities and meet their needs as well. So now I know that was a quick run through of just sort of setting the stage, but I want to turn it over to a couple of my colleagues. One that you are probably very familiar with, and a new face that you will be seeing a lot of as we expand our outreach work.
Thanks, Brenda. My name is Ann Colleton. I'm the Policy and Outreach Coordinator at GJP. And as in addition to this policy work that we do to change the laws, we also work on educating the community about laws that have changed or about their rights so that they know what their rights are and as well as their options. So today we're going to talk about voting rights in particular. Wait, if you can go to the next slide. So there's a lot of misinformation out there about who is eligible to vote in Georgia. There's about 200,000 people in Georgia who are disenfranchised because they're currently serving a sentence for a felony conviction. But there's more than 200,000 people who actually have completed their sentence who are eligible to vote now and often don't know. So I'm going to go over the law in Georgia. So anyone who is not currently serving a sentence for a felony conviction can vote. So that means that's 450,000 people. So another group of people who often don't know that they can vote are people who are sentenced under the First Offender Act or conditional discharge. Even if it's a felony, that is not considered a conviction unless the status gets revoked. And so they do not lose their voting rights. They can vote while they're under sentence. Don't have to wait for the sentence to be complete. People who are in jail can vote as long as they're not serving a sentence for a felony conviction. And if misdemeanor sentences don't affect voting rights at all. So as soon as someone's sentence is complete, meaning time in incarceration, probation, and parole, as soon as that is complete, the right to vote is automatically restored. All they have to do is re-register and then they can vote. You don't need your record expunged or pardoned. Again, you just have to re-register. No documentation is required. The Department of Community Supervision notifies the Secretary of State when someone's sentence is complete. But if someone wants peace of mind or isn't sure their sentence is complete, they can obtain a certificate of sentence completion from DCS or get a letter from the probation officer or something like that. Again, it's not required, but if somebody wants that peace of mind, they are able to do that. Brenda's already talked about our early termination of probation work that a law just passed a couple years ago. So that is directly related to probation because the vast majority of people who are disenfranchised in Georgia are on probation. So that's an important part. Our website has a lot of information, including materials that you can use if you're someone who does voting outreach to people. So please check out our website and share that. There is always a lot of confusion about fines and fees, right? Because what happened in Florida a couple of years ago, what we hear about from other states. So just remember that Georgia law is different and unique. And so on the Secretary of State's website, it says that you have to have completed your sentence and paid your fines. But the most important part is that this part that comes right after that, which is that fines that were imposed as a condition of probation are automatically canceled upon completion of probation. And your felony sentence is considered complete even if you have outstanding monetary obligations such as unpaid restitution fees, costs, and surcharges. So bottom line, if your sentence is complete, you can vote and fines and fees do not stop you. So again, check out our website and help us spread the word. I'm passing this off now to Dominique Harris.
Good afternoon, everyone. My name is Dominic Harris. I'm the outreach associate, and like my colleague Ann, I'm responsible for getting most of this information out. Spread the word, like that's major. I'm formally just as impacted, so getting this information out and empowering everyone is something I'm very much focused on because a lot of times we don't feel like we make a difference. So just understanding that once you complete your sentence, like that's all probation and fines and fees, you're eligible to vote. And also, if you haven't and you're concerned about, I still got probation left, you're eligible for early termination. So anytime you have those questions or concerns, I encourage you to visit our website and just reach out to any one of us and we'll help as much as we can. Wait. So Talk Justice is a forum we do every Tuesday, every other Tuesday, basically different topics about advocacy and youth training and just prison conditions. Displaying that to the community as we go forward and just try to be impactful. And every year we have the Talk Justice Affair. And this year we're going to focus on the mass incarceration of families and how they impact just not only the individual that's being incarcerated, but also their family, the community, and how this is a cause that all stakeholders should want to participate in. But I still just encourage everyone to just visit our website. We're part of the Justice Reform Partnership and continue to do this work with us. If I can assist anyone, we can assist anyone. We're always here.
All right. Thank you, Dominique, and thank you, Ann. So now we'll kind of transition into our time, really getting into the meat of our policy agenda for 2024. My name is Wade Askew. I'm our policy director here at Georgia Justice Project. So I first want to kind of dive in. Many of you have been partners of ours or have been kind of following or supporting our work for a number of years. So I want to first touch briefly on where we've been the last couple of years. Overall, we've been very fortunate to be a part of changing 22 laws in the state of Georgia in the last 15 plus years. Most recently, a lot of folks are familiar with our work in 2020 with Senator Tanya Anderson, whose wonderful leadership here in the state of Georgia helped lead to the passage of SB 288, which created, for the very first time, a path for folks to restrict and seal or expunge an actual conviction record in the state of Georgia. So as Brenda spoke about earlier, we are very deep into implementing that law every single day here at Georgia Justice Project after that landmark legislation was passed. We've talked about early termination of probation. We are doing our best to get the word out to folks that after 3 years of being on probation, they might be eligible to end their probation early, to again try to get at that very troubling statistic of how far ahead we are in the country in terms of leading the nation in probation rate. We are happy to report that in just a little over 2 years of that law being in effect, more than 20,000 people have had their probation sentences terminated early. But we know that there is still a lot of work to do there. Most recently, in 2022, we worked to try to reduce and provide a path back for driver's license suspensions when someone misses a court date. So if someone misses a court date, trying to first prevent their license from being suspended, and then if their license is suspended for missing a court date, providing a path back for folks to get that license back quickly, efficiently, and justly. So now, fast forward to today, we have 3 kind of overarching priorities for our policy agenda. You've heard us speak about this before, perhaps. That's because we are now in the second year of a biennial session, meaning Georgia legislature operates on 2-year cycles. And so everything that we were working on in 2023 is still here from 2024. So everything, all of our bills from a year ago are still alive. We're still working on them. And then we've actually added an additional bill that we'll touch on. So you'll hear us talk for the next 35, 40 minutes or so about occupational licensing, about expanding access to expungement, and about enabling victim-centered programs throughout the state. So I'm going to start with occupational licensing, SB 157. This is our biggest bill. This is the bill that has gotten the most media coverage that we've worked on here. And so I'll kind of talk about at a high level why it's needed and what SB 157 would do for the state of Georgia, and also kind of touch on just its status, where it is in the legislative process. So first, the need. 1 in 6 jobs in Georgia requires an occupational license. So stepping back for a minute, when I say the words occupational license, what do I actually mean? What I'm talking about is if I want to work in a certain profession, do I need some kind of government clearance, a government license, to work that job? So if I want to be, for me, a lawyer, or a barber, or a nurse, or a fingernail technician, the list goes on and on. There are 50 plus professions in this state, which again represent about 1 in 6 jobs overall, that require some kind of government approval, some kind of government licensure. And so for every single one of those jobs, there are a bunch of requirements as to what do I need to do to get that government clearance so I can work in this field. We're familiar with a lot of those requirements. I need to get certain education, I need to get certain training, I need to complete a number of requirements that are related to the profession to show I'm qualified to work this job. But at the very end of that process, government boards and agencies run a criminal background check, an arrest and conviction background check, to see, do we think, as the border agency, is there anything on this arrest or conviction history that we think we shouldn't give you this license? That is specifically what we are looking at. We are and I'll talk a little bit more about what SB 157 would do to affect that inquiry. But the key point to know in existing law is folks have to go through all their education, have to go through all their training before then. If they have an arrest or conviction history, they don't know until the very last moment, is this border agency kind of going to pull the rug out from under me and say, actually, we're not going to give you this license based off of this old event that happened years ago. That's what we are looking to change in our law. Just to highlight a little bit, just the economic need for this change. Brenda spoke earlier to the effects of our criminal legal system in terms of marginalizing talent, marginalizing qualified individuals who have a lot to contribute. Those contributions are across all fields in Georgia. Sometimes people ask us, if there are certain fields that people that are the highest demand for folks who have an arrest or conviction history, who want to do XYZ profession. And our answer is, folks with an arrest or conviction history are just as diverse in their talents and their interests as any other group of folks in the state. And so when we look at 1 in 4 of Georgia's highest demand careers requiring a license, we know there are many people eager to get in to these high need professions if just given the chance. So with SB 157, we have 3 overarching goals. The first is to offer clarity to folks who have an arrest or conviction history. So I kind of spoke about making this massive investment in education and training to go into a profession without actually knowing if an old record is going to pose a barrier at the very, very end. What we want is for folks to know upfront whether or not my arrest or conviction history is going to impact me as I try to go through the education, make this investment to pursue the profession of my choice. And so what that looks like is allowing folks to tell a board, tell an agency, here's my record, here's everything I've done since, here's why I think that I'm qualified to move forward, that this should not disqualify me. Can I have a binding decision, yes or no, whether or not I can move forward? So now I can move forward in confidence in making that investment in myself. The second is when that inquiry happens, when they do look at that record, to take as many, our goal was to take as many irrelevant records as possible off the table entirely. Meaning, if when a board or agency is looking at a record, we know that after a certain number of years, records are no longer statistically relevant. They don't predict whether or not I'm going to get arrested again. Usually after about 3 to 5 years, if I've had 3 to 5 years without getting arrested after I got my record, I'm no more likely to be arrested than anyone in the general population. So we want to make sure that boards aren't looking at these things that have absolutely nothing to do with whether or not I can successfully work in this profession. The third thing is to say, okay, if an offense is considered, how does the board do that? How do they consider it? Again, we are putting more structures, more kind of scaffolding in place to make sure that boards are just looking at what is truly relevant to the profession. For example, if I want to be a pharmacist and I have a conviction 6 months ago about prescription drugs, they're going to say that's relevant to our profession. If I want to be a pharmacist and I got in, a bar fight 6 years ago, 5 years ago, 4 years ago, does that have anything to do with my ability to be a pharmacist? Probably not. So what are we looking at here? What do we consider? And then also providing due process, giving the board, kind of putting on the board, you need to prove that that this record actually poses a threat to public safety. If I am in this profession, you've got to prove that, board. And also give me the ability to bring in all relevant evidence as to why I am not a threat to public safety and why I should be in this profession. Let me bring witnesses. Let me give you written documents. All of those basic due process protections that we have in most kind of legal proceedings in this country. But right now, they're not guaranteed if I'm seeking an occupation license. I also want to touch on the specific issue of long-term care facility clearance, so elder care facilities. We highlighted earlier how long probation sentences are in the state of Georgia. This directly impacts people's ability to work in elder care because current law disqualifies for someone for 10 years for over 200 offenses, disqualifies someone unless they get special approval for 10 years after sentence completion. And that means 10 years after probation is over. We're, as kind of our first step in trying to open opportunities to work in elder care facilities, we're trying to say, okay, let's start that 10-year disqualification period at conviction so that people aren't punished indefinitely just because Georgia keeps people on probation longer than anyone in the country. A lot of the reforms that we're talking about, actually all the reforms that we're talking about, are not us reinventing the wheel. We've taken best practices from around the country. So 80% of states in the country have adopted at least one of the reforms that we are proposing since 2015, some more than others. And actually, those who have adopted these reforms have seen a decline in recidivism because of the link of if I have a job, then I'm much less likely to get arrested. It is no surprise that if we open opportunity for qualified individuals to get licenses to then engage in a profession that has upward mobility, opportunities for entrepreneurship, it's no surprise then that the chance of arrest, the chance of and rates of recidivism decline, whereas states that are more restrictive actually see higher rates of recidivism. So as a matter of public safety, this reform helps everyone. Lastly, just want to kind of touch on where we are with this bill. We've had a lot of momentum, and we're fortunate to have a lot of supporters, a lot of partners in this effort, who you can see here. We have engaged with state actors, chambers of commerce, like-minded organizations across a wide spectrum for actually a couple of years on this subject. And so right now, SB 157 has already unanimously passed through the Georgia Senate, and our next step is hopefully getting through the House of Representatives. So we are grateful for all this support. We're grateful for all this partnership from so many. And now I want to turn it over to one of those partners, the wonderful Charlotte Garnes, to talk a little bit about the impact should SB 157 pass.
Thank you, Wade. So good afternoon. I am Charlotte Garnes, CEO and founder of Reinforce, but I just wanted to talk about the importance of Senate Bill 157 within the state, specifically from a personal and a professional standpoint for me. I am someone who's justice impacted. Prior to being incarcerated, I was a licensed therapist, transitioned to Georgia, and now I am one of those people that Senate Bill 157 can impact in a positive way. And not only just me personally, but so many individuals that I currently work with. Reinforce is a nonprofit that provides workforce development to not only justice impacted career seekers, but also to businesses looking to employ those individuals into their labor force. And so when I think of Senate Bill 157 and the people that I service, the businesses and those justice impacted career seekers, the biggest thing that stands out to me is the impact of Senate Bill 157 would have on Georgia's economy. So you heard some statistics, but with 4.5 million people in the state having some form of record, and 1 in 6 jobs in the state requiring occupational licensing, having Senate Bill 157, it would help steer individuals toward a more long-term employment opportunity, which are careers. And I think sometimes so many people focus on jobs instead of careers, but when you think of careers, it's more longevity. And according to the U.S. Chamber of Commerce, Georgia's employers have a surplus of 130,000 job openings compared to pre-COVID. But right now, the state is struggling with the workforce shortage. And that's evident by the fact that there's only 54 available workers for every 100 jobs open within the state. Also, like I said, with the career seekers, career-driven, for the justice impacted individuals, Senate Bill 157 would open up stability and income, and continuously growing in a profession that justice impacted people or individuals, they'll be growing in a profession that's theirs, where they'll have to continuously get CEUs, and they'll be learning and having opportunities and also benefits, and the security, because that helps to retain not only the justice impacted individuals, but the businesses buy-in to employ those justice impacted individuals within their careers. It also helps reduce the stigma associated, because it's a sustainable and it's credible. And it also would help with social reintegration, and it provides a sense of belonging. Also, with Senate Bill 157, we heard Wade talk about it prepares the justice impacted person with an understanding prior to spending that money. So it's cost effective. Just recently, I had a young lady that I was working with, me and another young lady that works with me, we were working with, and she brought her application in, and she had spent money, and she was unsure if she would be able to even go through the process. So we helped her go through the application and to answer that question. And we all know justice impacted individuals, what that question was, and to assist with developing her response and what that would look like. But they required so much of her prior to her even knowing, like, you would be, it would benefit you to complete this application, or no, it would not benefit you from completing this application. So I think a lot of clients, or a lot of our career seekers, are left in limbo because they have no clue if we spend this money, and not just on the educational side, but for every application, there is an application fee that typically boards say are non-refundable. So you just don't know if you're going to be getting that money, if you're going to be getting that opportunity to apply. And lastly, I think Georgia is able to obtain and to retain a skilled labor force. So I think it's important for us to understand that we're creating a fair and including system that allows everyone, regardless of their past mistakes, to apply. And also, this would be beneficial because it helps employers to have an increased innovation and competition within their labor force, which makes it more diverse and more skilled. So just through Senate Bill 157, it encourages the licensing boards to be transparent, consistent, and utmost accountable, which builds trust for us who's justice impacted. So I think Senate Bill 157 is definitely beneficial, not just for justice impacted individuals, but through for businesses and the state of Georgia as well.
Thanks so much, Charlotte. We're always so grateful for your partnership and the amazing work you do at Reinforce, especially if you're in the Augusta area, but anywhere in the state, check out Charlotte and her work at Reinforce. So now I'm happy to kick it over to Paige Jan, who is our supervising attorney and on our records team. So Paige, take it away.
Great. Thank you so much, Wade. Hi, everyone. As Wade said, my name is Paige Jan. I'm a supervising attorney with GJP's record program, where we have the privilege of working directly with folks through direct representation, through expungement desk, or even record events across the state. So I'm going to talk a little bit about record restriction in Georgia and what we are pursuing legislatively to make that landscape look better for folks. So first, I want to start with record sealing and why it works. We've already heard a good bit of information so far about why, but I want to kind of focus in on two big points here. Sealing eligible criminal history is really a win-win situation. It is better for public safety, and it is better for the economy. It's better for public safety because folks who are able to be steadily and gainfully employed, the reduction in recidivism is half, right? The likelihood of being rearrested is by more than half. Also, studies have shown that if someone is able to have their record cleared or restricted, it's extremely unlikely for someone to be convicted of a felony offense within 5 years of record clearing. And all of this makes sense because when folks have been able to obtain record clearing relief, They've already shown the unlikelihood of being rearrested, and they're able to get better jobs, which again drives down recidivism. It's also better for the economy, as these statistics show. Wages increase for individuals just 1 year after expungement by an average of 22%. The benefits just outweigh the cost here. That stat there, about over $5,000, is the saving per individual. It's just so significant because this leads to better jobs for folks, and increased tax base, and just more economic productivity. Next slide. Thank you. So here, this slide is just to provide everyone with a snapshot of record restriction law in Georgia. It's not exhaustive, it's not a complete list, but it does give you an idea of what we're focusing on when we're talking about record clearing or record restriction and sealing relief. A lot of other states refer to this as expungement, but our process is a two-step process called restriction and sealing. So you may remember a couple of years ago where we worked with Senator Tanya Anderson to pass Senate Bill 288. Under SB 288, a lot of great things were accomplished, but there were a few limitations that we're hoping to change. Specifically, most, but not all misdemeanor offenses are eligible. Folks are limited to restricting and sealing just 2 misdemeanor cases in their entire lifetime. And for felony convictions, individuals must get a pardon. And then when they do, they then have to still return to court and endure an additional process where they must ask the court to restrict and seal an offense so long as it's an eligible offense. So because both of these require a process of filing a motion to both restrict a record and seal the clerk files, in practice, what this means is that not everyone has access to relief. And in the long term, what we want at GJP is to continue expanding relief and automating the process. So all individuals in Georgia who are eligible for relief get the relief that they're entitled to. Finally, the other most common form of relief that we help folks with at the Georgia Justice Project is something called retroactive first offender. This is a remedy where folks who should have known and been informed of their ability to use first offender, a diversionary type of sentence, where they should have been told of that, it allows them an opportunity to go back to court and ask to be given first offender status retroactively. This is the most powerful remedy that we have in our record clearing tool belt for folks because it removes a conviction from someone's record. Although it is incredibly difficult to secure because the way the law is currently drafted, there is a unique requirement that the prosecutor must give consent or permission before anything can ever be filed in court asking for retroactive first offender. Next slide, please. So what can we do with some of these limitations that we mentioned in both Senate Bill 288 and the retroactive first offender statutes? We can pass Senate Bill 157. You may remember some of these provisions from years past. Senator Anderson was the first to champion these back in 2022. And if they pass, in addition to providing some technical cleanup for our current law, a lot of really great things can happen. Specifically, it would modestly expand misdemeanor restriction and sealing eligibility. So what this means is it would allow offenses like misdemeanor theft by taking or theft by deception. It would allow it to now be eligible alongside similar offenses that are already eligible under current law. Also, it would remove the lifetime limit of just 2 misdemeanor cases from someone's eligibility to be restricted and sealed. This is really key if we want to be able to move towards clean slate legislation. Also, just to note the statistic here that we have on the slide, once someone has already waited 4 years in order to pursue this relief, they are already at a very low risk of a new arrest. And that's despite having multiple old convictions on their record. SB 157 would do a few other things. It would streamline the process for restricting and sealing pardoned offenses. And finally, it would ensure that people seeking retroactive first offender will have their day in court by simply allowing them to be able to file the request in court without the unnecessary barrier of securing the prosecutor's consent first. Their voice will be able to be heard. In the years ahead, of course, we'll continue to work to expand eligibility for record clearance and automating the process so that people who are eligible for relief will actually get to it. Next slide. Also wanted to take a moment to talk a little bit more about House Bill 909 and how it will improve our current First Offender Act law. So we talked just a few slides ago about first offender in the context of retroactive first offender. But just to dig in a little bit deeper about what first offender is and how it operates, first offender is a piece of second chance legislation. It's been around since the late 60s. And it is a tool that every person has in their tool belt. What it means is that each person can use first offender or their first offender status just one time for an eligible misdemeanor or felony case. It is used in the context of having a pending case. You can use it just one time. The court has the ultimate discretion as to whether or not to allow someone to use first offender. But if the court does allow for someone to be sentenced that way, the benefit is that it avoids a conviction ever being entered on the individual's record, assuming they successfully complete their sentence. So in addition to first offender being an incredibly important diversionary pathway for folks leading to a non-conviction upon completion, records are intended to be kept private with very specific statutory limitations on how those records could ever be used. So despite all the positive things behind this law, the next slide is going to tell us a little bit more about how is it working in application. Is there a problem? And there is, because in current practice, First Offender Act is not living up to its promise. So many folks who receive first offender and they finish their sentence, they go on living their life thinking that my record has been expunged, restricted, destroyed. It's not obtainable. But years later, years down the road, the record pops back up and they reach out to GJP and we help clients take care of it. But why does this happen? Why is there this confusion? How are these records still available? Well, you may remember I talked a little bit ago about record clearing in Georgia, how it's a two-step process, how when we are actually clearing someone's record, we are talking about restricting an official record or a GBI record, and then we are sealing the clerk of court records. So it is a two-step process. Current First Offender Act law only deals with the former. It only restricts the GBI record, and it does nothing on its own or automatically with the sealing of the clerk records. This is, of course, a huge issue as technology has increased and more records are available on everyone's fingertips. So it is quite common for first offender cases to appear on a private background check. And sometimes first offender records even appear in a way that is confusing to an employer that makes it look as though it's a conviction when it is not. So in application, it is really not an effective remedy for folks with how the real world works. So many folks are told, you've done this, you can move on, you can live your life, when the reality is it prevents many opportunities and closes many doors. So I am so excited about this bill because what it does is it closes that loophole. And how it does that is it requires both restriction and sealing at the time that someone enters a first offender plea. It takes care of both of those necessary steps. This will ensure for folks that they can complete their sentence successfully and prevent any private records from popping up down the road and getting in the way any further. So with that, I'm going to pass it back to Wade to discuss a little bit more about victim-centered programs.
All right, thank you, Paige. So I will kind of touch on the third prong of our agenda, enabling victim-centered programs to really thrive in the state. So as with all of our policy priorities, our work here in promoting victim-centered programs is rooted in our direct service work. So want to talk just a little bit about Restorative Justice Georgia, which folks on this call may have heard of, what it is and how that relates to what we're talking about when I use this term victim-centered programs. So restorative justice is a type of actually victim-centered program that is can potentially be used as an alternative to the traditional criminal legal system. I won't dive into the weeds of this visual here in terms of how the traditional criminal legal system process as a case versus restorative justice, I'll kind of focus on the big picture, which is the traditional legal system, traditional criminal legal system. If I'm arrested, then I go through a process that many of us are familiar with, where law enforcement and prosecutors might try to put evidence against me to say Wade has done this thing that is, against our statutes, and we want to punish Wade by doing X, Y, Z, and figuring out a sentence if I am ultimately convicted of that offense. And so it is a process. That process that I just described, I never actually mentioned any concepts about me, someone who allegedly did something to break a statute, break a law in this state, and to allegedly, theoretically, create some harm on some level. There's never actually any discussion there of, well, what about my desire to make things right? If I do feel like I've done something, what about my trying to make a community whole? What about my trying to actually help, if there was a victim in this situation, help the victim here? What about the victim's point of view of actually being consultative? Well, what do you want to happen? What do you think would make this situation right? None of those are really a part of our traditional criminal legal system. And so what something like restorative justice or a victim-centered program, what that does is flip things on its head to say, if I, do something that hurts somebody in some way, which in my life, goodness knows I have done plenty of times, then who I'm answering to is actually who is affected by that harm, who has been affected and what do they need. And so restorative justice brings together a victim, centers their needs, members of the community who may have also been affected. And then if I'm the person who created harm, then I'm actually given the opportunity to be accountable and to try to right that wrong and make us whole again. That is the goal. That is the vision of restorative justice. And we are engaged on the ground at Georgia Justice Project with multiple jurisdictions to actually provide that as an alternative to traditional prosecution. These types of programs are shown to drive down recidivism. From a victim point of view, victims tend to report back a much higher rate of satisfaction with a program like restorative justice than the traditional criminal legal system. And also they can, if used as an alternative prosecution, can prevent someone from gaining an arrest or really specifically a conviction. So those are some of the benefits that I just touched on. It's also a tool that prosecutors have signaled that they actually want, that not every case, even in their mind, is appropriate for prosecution, even in the mind of many prosecutors that we speak with. They also are really a community asset. Like I said, not only do these types of programs offer the opportunity for kind of a communal healing, but they also, through reduced recidivism, increase public safety. So what we want to do is enable these types of programs to thrive. It goes back to the first part of our mission of reducing the number of people under correctional control in Georgia. Again, when used as an alternative prosecution, it does just that, as well as the second part of our mission, reducing barriers to reentry, because statistics show that folks who go through a process like this have much lower recidivism rates. So, and also encounter less barriers as they move forward because they don't have a conviction history. And so any type of program, whether it's called restorative justice or called something else, that centers the need of community, centers the need of victim, allows for open, honest conversation, allows for kind of that healing to take place, we want to enable that to exist. And so what our proposed legislation would do, we're partnering with Representative Terry Nolovitz on this. So hopefully a bill will be dropping soon that you can see. What our bill would do would be enable these kind of programs to exist by creating an evidentiary privilege. Meaning, if I say something in one of these victim-centered programs like restorative justice, if I say, yes, I'm very sorry that this happened to you, how can we make it right? Traditional criminal legal system can hold that against me to say, you just admitted that you did something and you want to make it right. use that against you in court. However, those types of statements are critical in making these kind of programs work, making these kind of programs thrive. Without open and honest dialogue, these programs cannot exist. And so we have to say that anything said in these settings needs to be privileged, meaning it can't later be used against me in court. This type of privilege is actually very common in the law. You see some of the examples here of ways that current law actually uses this type of privilege to enable those communications to be used in settings such as mediation, discussions between a clergy member and a member of their faith community, apologies made by healthcare providers, and other states such as Texas have already made this privilege applicable in these types of victim-centered program settings. So that is kind of the overall view of what we are going to be working on here in 2024. I do want to just recognize a couple of things as we close out. One is we want to recognize that our agenda is by no means the beginning, the middle, or the end of criminal legal reform in the state of Georgia. And we also recognize that there are people in this state who have arrest and conviction histories that are not touched by our current legislation and not touched as much as we wish. And so what we want to do is acknowledge that there are many people that we wish that we could do more for in this legislative session that for political reasons, maybe we're not able to, but that we never forget that all Georgians deserve a second chance. All Georgians have much to contribute to our communities and are much, much more than a record that may have occurred years ago or may have occurred recently, that all of us are more than one event in our lives. And so we want to recognize that we stand with all those who have been touched by the criminal legal system, and we are committed to working in community, especially with those who are impacted directly by the criminal legal system, to try to change the way our system works in the state of Georgia. If you would like to engage with us, if you would like to partner with us, you can see here how you can share your story with us, how you can volunteer, how you can be part of our legislative agenda. And we're always happy for you to reach out directly to engage about our agenda, or also with our direct services if you need help or you know others who need help. So thank you very much again for being part of our legislative kickoff and being with us on this journey. And I'll check if we have any questions that we can address here, and I'll try to do it in the remaining time that we have together. So I see one question here: if already convicted and completed probation, how would restorative justice be used? That's a great question. So restorative justice and these kind of programs can really be used at any point. They can, but it might serve a different purpose depending on the timing of when it's used. So Restorative Justice Georgia, where we're engaged, is trying to preempt the criminal legal system to say, instead of that path, we think something else is better. And obviously we have a different vision at Georgia Justice Project, just generally on how we address issues that right now are being dealt with the criminal legal system. However, there are programs throughout the country that are, whether it's restorative justice, or you'll hear the terms victim offender mediation and otherwise, that is providing these types of settings while someone is incarcerated, while they're on probation, or even after a sentence is complete. In those situations, it doesn't necessarily have the same impact of preventing a record of conviction from ever taking place. They have other benefits in terms of kind of that healing for all parties involved and otherwise, but it doesn't have that same impact as something like Restorative Justice Georgia that diverts the criminal legal system from really ever being engaged in the process. So hopefully that answered that question. I don't see any other open questions. There's one right now. Interested in volunteering? Do I have to be a lawyer? No, you do not have to be a lawyer. And no, there is no specific background needed. Many of our volunteers are lawyers, and they might help on individual cases or some legal clinics that we have. However, we have plenty of folks who have volunteered who are not lawyers, who help in any number of different projects. So if you are interested in volunteering, kind of regardless of your skill set, and I see Rohit, one of our wonderful volunteers, actually just chimed in, volunteering without being a lawyer. Rohit has a wonderful skill set that we don't have at GJP that is helping really expand the impact of our work and look into issues that traditionally we haven't been involved in. So kind of regardless of your background, if you want to volunteer, reach out and we'll see if we can work something out. As other legislators signed up to sponsor or get involved with our legislative agenda? It's a great question and one that I should have addressed as we were going through. So first, SB 157, I failed to mention that Senator Brian Strickland is the author of that legislation. He has been a wonderful champion of this issue for more than a year and has been a real catalyst in changing the conversation around occupational licensing in Georgia. So we're very, very grateful to work with Senator Strickland on that legislation. Again, SB 157 includes our occupational licensing as well as some of those record restrictions, sort of cleanup provisions that Paige talked about. HB 909, which is the First Offender Act sealing bill, what Paige talked about of folks being told your First Offender Act sentence is going to be kept private, but our current law hasn't really kept up with how private background checks work. So that promise isn't currently being fulfilled. HB 909 is authored by Representative Lisa Hagan. So we are excited to work with Representative Hagan on that. Both of those bills also have very strong lists of co-sponsors that we're grateful are part of the effort on both. Like I mentioned, the bill about victim-centered programs, that is going to be authored by Representative Terry Nolovitz, and we're anticipating that that bill will be filed soon so that we'll have a bill number to share out. If you stay engaged, if you sign up for our action alerts, then you will be getting an email once that bill is filed, so you'll know the bill number and know kind of how to engage in that effort. Okay, I think that got the outstanding questions as we are coming up at the 1 o'clock hour. So once again, just want to thank everybody for being part of today's legislative kickoff, and most importantly, for being part of the GJB community, for being partners, for being with us kind of on this journey and being with us in these efforts. We are very, very grateful, and we hope to stay engaged with you throughout the session and beyond. And hopefully next time we talk, we'll be talking about implementing some legal improvements to our system here in Georgia. Thank you again.